In just over a century, Jewish Americans, a group comprising approximately 2.4% of the U.S. population, or about 7.5 million people as of 2025, have played a disproportionate role in shaping the nation's civil rights laws, hate crime statutes, and broader legal norms governing discrimination, speech, and protected characteristics. This influence stems from a network of advocacy organizations founded primarily between 1906 and 1920, including the American Jewish Committee, AJC, Anti-Defamation League, ADL, American Jewish Congress, AJ Congress, and key contributions to the National Association for the Advancement of Colored People, NAACP, and American Civil Liberties Union, ACLU, with the Southern Poverty Law Center, SPLC, joining later in 1971. Through drafting model legislation, litigating landmark cases, and providing interpretive guidance, these groups have helped construct the modern framework for anti-discrimination laws, from the Civil Rights Act of 1964 to the adoption of the International Holocaust Remembrance Alliance, IHRA, definition of anti-Semitism in federal and state policies. Yet, the average American remains largely unaware of this dynamic, with surveys focusing more on perceptions of anti-Semitism than on the specific organizational roles in legal development. This lack of broader recognition underscores how specialized advocacy can profoundly alter societal norms without widespread public discourse. The process began in the early 20th century amid waves of Eastern European Jewish immigration, when these organizations lobbied against quotas in laws like the Immigration Act of 1924 and advocated for refugee admissions in the 1930s. By mid-century, their efforts contributed to authoring key provisions of the Civil Rights Act and Voting Rights Act, establishing protected classes that extended beyond race to include religion and national origin. For instance, Jews made up a significant portion of white civil rights workers, with estimates suggesting over 50% involvement in some campaigns, including the Mississippi Freedom Summer of 1964. In recent decades, the ADL and AJC have been instrumental in promoting hate crime enhancements and bias reporting systems, influencing everything from federal executive orders to corporate terms of service. Notable 2025 developments include Harvard University's adoption of the IHRA definition in January, becoming the first major campus to do so that year, and ongoing state-level integrations, such as Florida's 2025 statutes explicitly incorporating IHRA language. This trajectory raises questions about how a demographic minority achieves such leverage. Through high representation in the legal profession, estimated at 10 to 15% of lawyers, far above population share, and judiciary, historically up to 19% of federal appellate judges, combined with strategic coalition building and expertise in public interest law. While precise 2025 figures for legal representation are not uniformly updated, historical trends indicate sustained overrepresentation driven by cultural emphasis on education and professional achievement. Public awareness of this influence appears limited, often overshadowed by broader discussions on anti-Semitism rather than specific contributions to legal evolution. Recent surveys, such as the American Jewish Committee's 2024 poll on anti-Semitism attitudes, show that while 75% of Jewish Americans view being Jewish as important to their identity, broader American polls rarely probe knowledge of organizational roles in lawmaking. In that poll, nearly 6 in 10, 56%, American Jews reported altering their behavior due to fear of anti-Semitism, a sharp increase from previous years, highlighting heightened community concerns but not directly addressing public understanding of legal impacts. A 2025 Jewish Electorate Institute poll indicated strong Jewish opposition to certain policies, such as executive orders, with 72% disapproving of specific political performances, but general U.S. surveys suggest low cognition of how groups like the ACLU or ADL have shaped precedents in free speech or hate crimes. This lack of visibility may stem from the technical nature of legal advocacy, where influence operates through amicus briefs and model statutes rather than public spectacle, allowing significant changes to occur without widespread notice. The 2025 Annual Assessment of the Jewish People by the Jewish People Policy Institute further notes evolving identity amid these influences, reporting stable demography but rising emigration among young secular Israelis and declining cohesion under threats like war and, what they call, anti-Semitism, yet it emphasizes limited broader awareness of these dynamics. The seeming improbability of a 2% minority constructing much of the legal landscape reflects America's pluralistic system, where expertise and organization can amplify voice. Historical parallels exist. During the civil rights movement, black-led groups like the NAACP, often allied with Jewish organizations, influenced majority laws despite being a demographic minority. For example, Jews played key roles in founding and funding the NAACP and participated heavily in events like the March on Washington. In medieval Europe, minority Jewish communities influenced majority societies through financial and legal advisory roles, though often under duress, such as court Jews advising rulers on finance and diplomacy amid restrictions and expulsions. Similar patterns appear in post-colonial states, where small ethnic minorities have held outsized legal and political sway due to colonial legacies that institutionalize differences, often leading to tensions in ethnically divided societies. In the U.S., Jewish overrepresentation in law, driven by emphasis on education and professional achievement, has enabled drafting of laws like the Violence Against Women Act and expansions of Title IX, overseen through ongoing litigation and monitoring. This dynamic illustrates how active participation in legal spheres can yield significant outcomes, even for minorities. A 98% majority allowing this dynamic speaks to the strengths and vulnerabilities of democratic pluralism. Laws are shaped by active participants, and passive majorities often defer to experts. Colonial legacies show how minority elites influenced majority societies through institutionalized roles, as in ethnically divided post-colonial states where small groups held legal sway, reflecting parallels in how expertise can bridge demographic gaps. In America, this has resulted in a legal regime where organizations like the SPLC's hate tracking influences deplatforming, and ADL training reaches law enforcement, all without broad public scrutiny. The 2025 annual assessment of the Jewish people notes evolving identity amid these influences, yet general awareness remains low, highlighting how specialized advocacy can redefine norms quietly. As pluralism enables such contributions, it also prompts reflection on balancing influence with broader societal input, ensuring that legal frameworks evolve through inclusive processes. Conclusion: the disproportionate leverage of a demographic minority. Over the past century, Jewish Americans, consistently around 2 to 3% of the population, have exerted an outsized and enduring influence on the development of U.S. civil rights law, hate crime statutes, and the broader architecture governing discrimination and protected characteristics. Through a cohesive network of advocacy organizations founded primarily between 1906 and 1920, and sustained by high representation in the legal profession and strategic coalitions, this minority has played a pivotal role in drafting landmark legislation like the Civil Rights Act of 1964, litigating transformative cases, and shaping interpretive frameworks from disparate impact doctrine to the widespread adoption of the IHRA definition of anti-Semitism by 2025. This dynamic reflects the strengths of American pluralism. Organized, expert-driven advocacy can profoundly shape national policy even from a demographic base far below majority thresholds. Historical parallels, from Black Jewish alliances in the civil rights era to medieval Jewish advisory roles under constraint, illustrate how minorities leverage education, professional concentration, and institutional persistence to influence majority societies. In the U.S. context, this has produced a legal regime enriched by minority perspectives, yet often evolving with limited public awareness of the specific actors and mechanisms involved. The result is a framework that bears the clear imprint of sustained, intergenerational effort. Protections initially forged against so-called exclusion and distorted perceptions of bigotry have expanded into comprehensive norms governing speech, education, employment, and association. While this influence has advanced equality in many dimensions, its disproportionate origin and relative invisibility to the broader public highlight a core feature of democratic systems. Laws are frequently shaped by those most actively engaged, with passive majorities deferring to specialized expertise. This legacy remains a testament to effective minority advocacy within an open society, raising ongoing questions about balance, representation, and the quiet forces that redefine national norms.